My name is Nina Fundiller-Walden. I'm the Managing Director of Chai Mitzvah, the Resource Center for Jewish Engagement. Chai Mitzvah, the sponsor of Scholar Circle, is a Jewish engagement program that partners with over 700 organizations and has worked with over 9,000 individuals in small group learning, social action, and spiritual and ritual development. We have over 20 curricula tailored for small group conversation for teens and adults, lay or professionally led. To learn more, please visit our website, chaimitzvah.org. The Scholar Circle hosts lectures by prominent scholars every 2 weeks on topics related to Israel and the Jewish community, geared towards rabbis, educators, and lay leaders who are charged with explaining the complex issues the Jewish community is facing. To that end, each lecture will have a resource guide that will be sent to you after the lecture. A recording of each lecture will be accessible on our website and shared with you through email. Our featured scholar is Dr. Olga Kirschbaum-Sharansky, a historian, editor, co-founder of Tel Aviv Review of Books, and visiting fellow with the Tel Aviv Institute. She received her PhD in modern European history from New York University, focusing on intergroup and interfaith relations, as well as nationalism, colonialism, and international politics in the modern period. Before I welcome our scholar, a couple of housekeeping items. To submit questions, please use the Q&A button on your screen. Q&A will be held at about 40 minutes into the lecture, but you can submit questions anytime throughout. The lecture recording will be sent to your email in a few days and will also be available on our website at chaimitzvah.org. Now, Dr. Olga Kirschbaum-Sharansky coming to you from Israel.
Hi, welcome to everyone. I'm pleased to be here on the talk on this rather vast and complicated topic. The objective of the talk, from my perspective, is to kind of give people a lay of the land, so to speak. What are the main issues between international law, or in the relationship between international law and the Israeli-Palestinian conflict writ large? So to that end, today I'm just going to give you sort of a brief kind of overview of international law itself. Then we're going to talk a little bit about international law and the creation of the modern state of Israel. And then we'll get into the recent judgments and, if you will, action in various international courts. And in so doing, we'll talk a little bit about the different institutions and what their jurisdiction is, and what their what kind of ability of enforcement, or what power they have and what influence they have. So to start off with, as an introduction on international law, I think most people understand that the idea of law, relates to the citizens or subjects of people of a certain culture. It's one of the foundational things in modern anthropology, that we know that different peoples have their customs and their laws. And international law has sort of come in the area between peoples, or with foreign peoples in relation to one people. So the kind of, when we think about international law, some of the earliest things that people examine or consider are treaties, when two groups are at war, for example. So some of our earliest documents that today fall under the rubric of international law are treaties in ancient Mesopotamia between two peoples deciding on the borders and the end of a conflict and the conditions of the end of conflict. Another aspect of international law is how foreigners are treated in a particular area, right? Or also what is permitted or not permitted in war, right? So we have aspects of this in Jewish thought, in the Torah. Some of them are codified in Jewish law, right? What wars are permitted to the Jewish people, which wars are not, what to do with prisoners of war, what to do with booty, and how the world should be, whether conquest is something that is admirable, or whether it's not. So if you've been following the biblical texts over the past couple of weeks and up and through the summer, some of these issues of international law come in as B'nai Israel are going through the territories of other nations. And so first there's a whole literature of this in the text about that. You have to first ask to go through, you have to offer peace before you then fight. So these are internal Jewish rules about what's essentially international law, and laws of war and laws of peace. And then there's also the issue of how to treat foreigners. So we have, of course, as I mentioned before, prisoners of war and the rest of it. But we, in Jewish law, you have categories. Most or a significant amount of Jewish law applies even to non-Jews. You can't willy-nilly steal from a non-Jew or just murder them willy-nilly or the rest of it. So there's international law is sort of assuming certain legal norms, and this is important, legal norms or ideas outside of a citizenship or subjecthood. And then there's certain customs, what is customarily the land of one group or customarily the land of another group. So in Jewish law, the kind of international norms are expressed legally in this concept of the 7 Noahide laws, that these are laws that from the Jewish perspective, all human culture should follow: no idolatry, no blasphemy, no murder, no stealing, no illicit sexual relations, having a court system, and not eating from a live animal. Now, no stealing and no murder are very important as basic concepts, legal concepts, international concepts. And while this might sound a little esoteric, it becomes very important because in the modern period, there's a very strong overlap between human rights and international law, and we'll get to that later. So the foundations or some of the ideas of international law have really been around since there are organized groups who encounter each other, whether to trade or to make war against each other or to decide on each other's boundaries. So it's really something very old. But unlike national law, and this is really a critical difference, international law doesn't have, and this means this is not just in the past, but it's also true for today. It's not based on one universally accepted body of laws or rules. And this is one of the reasons why there's a lot of differences of opinion in international law, even when, let's say, there might be consensus or majority view things in one way, that we also often have dissenting opinions that take a different take. Now, the sources of international law in the past as today are really threefold. One of them is treaties, which are voluntary and consensual. So two groups, after there's a military defeat or there's a stalemate or whatever the case may be, then there's a treaty which leaders sign for their various people. So that's one form, or there might be a treaty for trade. So a treaty is a way for two groups to make a commitment, and increasingly in the modern period, treaties also relate to subordinating national law to some international set of rules. So that the nation agrees that in their national law they will follow the rules that are set in the treaty. So that's one important source of international law today. And non-signatories of treaties are often then not subject to the jurisdiction of the courts that are dependent on these treaties. That's one. Another one is more difficult, is custom. Right, so this comes into play where there's use of resources, or there's people inhabiting in a certain place, or a certain way that things are done. And another third form, or third source of international law, are certain principles of law or legal norms that are accepted by the international community. So you can see that these two last, that all three of these sources of international law have some difficulties, unlike kind of the setup of a functioning nation where there's a set of laws and citizens. If it's actually a functioning society, so there is a set of laws and people have to follow them, and then there's a court that tries people who don't follow them. And then in the case of international law, so treaties depend on people actually signing and then ratifying them. Customs can vary, and interpretation of customs can vary, and the issue of what is accepted as international law or international legal principles also varies. It can change very radically, and we'll talk about that. One of one of the major changes in the modern period is the shift away from accepting the right of conquest, which was sort of a principle of law that was largely accepted for most of for a lot of world history, shall we say, to the principle of national self-determination as a significant change in international law. And even the principle of national self-determination itself, that a country, no matter how small or big, sort of stands in equal status in the international arena to another country that's larger or has greater force, is itself also an important new principle in international law. So now that you see that these are the sources, then there's been, even though from antiquity to the present, most countries and peoples had their own kind of traditions of how they dealt with others in war and what were their rules, the idea that there should be some kind of universal principles is quite old. It comes from the Roman period. It's called jus gentium. And the reason for that is that, over the course of history, there are periods of tremendous amount of war and bloodshed that lead people to understand that if sort of things are just left to their own devices, then it's kind of the law of the jungle, and that can be ultimately extremely destructive. And you see this in Chinese history, where there's a warring period, and then after that, you have the development of legal schools that deal also with diplomacy. They deal with how groups should interact with each other, because there was a sense that things had just become too excessive. And the modern development of international law kind of follows this pattern in the 20th century, in that you have, in addition to the period of the Peace of Westphalia, where you have the beginning of the recognition of sovereignty of the different nations, you have, over the course of the 19th and 20th century, and the 20th century in particular after World War I, the development of international courts and international bodies, starting with the League of Nations, and then followed after World War II with the United Nations. And then with the United Nations, you also have the development of human rights. And so here you have an effort on the part of the international community to create international peace. And part of that effort involves courts and involves the development and the extension of international law. So this is where we get to two of our important players in what has been in the news recently. So one is the International Court of Justice, and the other one is the International Criminal Court. So these are two separate entities, and they have two separate functions. The International Court of Justice is part of the UN. And so when a state is a member of the UN, that they're kind of automatically signatory to the statutes of the International Court of Justice. And the International Court of Justice adjudicates between states. So this is its function, and any member of the UN can file a complaint and bring a complaint to the International Court of Justice, which will then address it. Now, the International Court of Justice doesn't really, it has jurisdiction over various areas, but really the teeth of the United Nations, their ability to enforce anything really comes through the UN Security Council. So it's not that the International Court of Justice is meaningless, but its ability to enforce is dependent on the Security Council. And the Security Council then has the option of military or non-military means to deal with an imminent threat to peace. That's its purpose. And those might include sanctions, or they might include bringing peacekeepers to a certain area. And the Security Council is subject to a veto. So because the International Court of Justice doesn't have, like a state court, doesn't have a body that can enforce its laws, there is a school of thought that says that really international law is not like national law, that it's really a set of moral principles. It doesn't, because its courts do not function like national courts with the ability to enforce in the same way. So there, even as we've discussed, there are sort of issues with the sources of international law, and then there's the question of really what is its function in contemporary society if it can't really fully be enforced. So that's for the International Court of Justice, and we'll get to the two cases that relate to Israel in a moment. We have the other court that has been in the news recently is the International Criminal Court. Now, the International Criminal Court is separate from the International Court of Justice. It's a much newer, much more recent institution, although both of them are seated in The Hague, so people can get somewhat confused about that. But it's a criminal court, and the idea behind it was that to prosecute individuals who had committed severe crimes, crimes against humanity, war crimes, so that they would not escape justice. And so the International Criminal Court, though, unlike the UN, in a way, both like the UN, except in the UN, to be a member, you automatically sign on to the statutes of the International Court of Justice. But the International Criminal Court, you have to be a signatory to the Rome Statute. And there's important states who are non-signatories to the Rome Statute, the United States being one of them, China being another, Russia being another, and Israel being another. And so where there's no jurisdiction for the court where for a place that is not a signatory. But this, we'll get into some of the technicality of that in a moment. The other aspect of the International Criminal Court that's important to understand is that the International Criminal Court cannot prosecute something that a domestic court is prosecuting. And then the third aspect that differentiates it from the International Court of Justice is that it's really about the prosecution of individuals, so individual criminals. And they felt the need for this. The international, if I don't know how many of you, I'm old enough to remember the Yugoslav wars in the 1990s, but so there were ad hoc courts that were created to prosecute the war criminals of the Yugoslav courts, because there was a feeling that there wasn't any other body. And after World War II, there were also courts that were created to do that. And this, the prosecution of individual perpetrators is not something that's done by the International Court of Justice. So those are the two bodies that are involved right now in the case of Israel. And so before we get to the two cases and what is going on with them, I want to look a little bit at Israel and also the Palestinian territories, or the state of Palestine, because there's been a concerted effort by the PLO to gain through international legal means the status of the state, where international law falls and what its relationship to these issues are. So one of the issues that comes up in international law, as I discussed before, is the question of boundaries of a territory, or the question of the sovereignty of a territory. And so in the case of the state of Israel, there are a number of perspectives on how, in what way Israel is a legal state. Right. So one of the perspectives in relation to the legality of the state of Israel is that it, through first the Balfour Declaration and then the various treaties after World War I, the British Mandate was created. And from the British Mandate, then the state of Israel was the kind of successor to the British Mandate. So there, the point is that the treaties are really what, and then the subsequent, after the treaties and the declaration of the state, the subsequent recognition, de facto and de jure, of various countries are what create the legality of the state of Israel. So that's from the perspective of international law, that's there are groups who view that it's really the treaties post World War I that are the primary aspects of that create the legality of the state of Israel, and then it's de jure recognition by other states. There are other groups that view the importance of the UN resolutions, and I think here we need to take a little moment to talk about the relationship between UN resolutions and international law. Most UN resolutions are non-binding, except the Security Council resolutions, which can be vetoed by the powers of the Security Council. And so the status of these resolutions in international law is that they're not, they don't have the same status as treaties. So that's so there are people who do not view, even though the UN vote for partition, which sort of in symbolic terms created the possibility of a Jewish state, for some people, from an international legal perspective, it's less significant than the post-World War I treaty. So that's another matter to consider in relation to international law. Then there's another principle that relates to international law, and we spoke about it in terms of the three sources, so treaties and custom, and then international principles. So the principle of national self-determination is another principle that is invoked in terms of the legitimacy of the State of Israel in international law. Now, some of these same issues, of course, come up with the question of the legitimacy of the State of Palestine in international law. And so those people who view, so there's a school of thought, because the Palestinian, the PLO has submitted to the United Nations the desire to be accepted as a state. And has done this in 1988 and again in 2012. And we also now have, as many of you have followed, the recognition by various states of the State of Palestine. So this is an attempt by the PLO to create a State of Palestine de facto and de jure through international law rather than through a negotiated solution with Israel. And it has been blocked. The Palestine does not have full state member status at the UN by a UN Security Council veto by the US, but it does have a sort of semi-member status, which has enabled it to participate in various UN institutions. And this is important for the development of the cases that we are going to look at momentarily, the recent cases in that Palestine can bring a case or complaints to the International Court of Justice against Israel or on its own territory against other actors, which it could not if it had no status in the UN. So this is an important point. What I've discussed in terms of the legality of the State of Israel and Palestine also relates to the question of, and this is another area of contention with regard to international law, of the West Bank and Gaza, which so there are numerous questions of international law that come into the status of the West Bank and Gaza, and there's also a variety of opinion. Now, the majority of people who deal with international law have sided, and we see this in the most recent decision, with the opinion that Israel's presence in the West Bank and Gaza is illegal. That is not to say, and this is an important point, that the majority views things that way is not to say that there isn't legal validity to dissenting opinions or differing opinions. Particularly because in the world of international law, the sources of international law and the potential of conflict between treaties and custom and legal principles is much higher than in sort of a body of national laws. So the positions, so there are sort of kind of a range of positions on the legality of the West Bank and Israel's presence, and the positions are more or less as follows. So there's one position which is held primarily by Israelis, some Israelis, not all, and some members of the international community, but it's a minority position, which is that there is a notion in international law that the last governing body and the last set of boundaries, when there is a change of regime or a change of government over an area, are the ones that remain. So in cases, for example, where there's decolonization, or if you take the end of the Soviet Union, for example, the administrative boundaries of republics, which then gained independence from the Soviet Union, became the boundaries of those republics. And so there is a position held by some Israelis that, in fact, Israeli sovereignty extends over the entire area of the mandate, the British mandate, because that was the previous administrative set of administrative boundaries and unit that existed, and Israel's the only state that emerged from that, and therefore all of the West Bank and Gaza were part of that, and then they were subsequently in the War of 1948 conquered and militarily occupied by Egypt for Gaza and Jordan for the West Bank. But that military occupation didn't annul this legal principle of the continuation of the boundary. So that's one perspective. Another perspective that's taken by more the European Union and members of the international other states is that the principle of Palestinian national self-determination trumps this other principle of the continuation of the legal boundaries, and also so therefore this other principle is not important. And then there's a third view, which is a view that often is expressed by the Israeli government, which was that the acquisition of the territories in 1967 was done defensively, and therefore the laws of occupation and the laws against occupying or annexing don't apply, because Israel acquired those territories defensively and continues to have defensive reasons to maintain them. So those are kind of the three positions that are frequently brought about in the literature. So what is happening today, and really what is going on? So since the PLO has been attempting through the United Nations and through the use of international law to assert its sovereignty unilaterally, really, as I said, since 1988, and particularly again in 2012, as it gained through a series of decisions and votes, as it gained a non-member status, but sort of kind of an official status. This then enabled it to participate in international courts, and so this is precisely what it has done. It has brought forth complaints to the International Court of Justice, and these complaints were brought forth already in 2019, and investigations were pursued from that period onwards. So the most recent judgment with relation to the West Bank has to do with complaints brought by the state of Palestine to the International Court of Justice already before the current conflict. So that's the first issue that's come up recently. Now, Israel doesn't accept the decisions made on a number of grounds, most notably that they say that they interfere with a negotiated solution and they undermine the Oslo Accords, and that the state of Palestine is not a state. So there are that has been the official response. And then, as I said, there's a kind of minority view within Israel that the West Bank is not really even occupied in the first place, due to this principle of the continuation of the administrative borders and areas when one state replaces another. The other case that is brought forth to this UN court has been the case brought forth by South Africa in relation to the current conflict in Gaza. And I should mention that the 2019 case also related to war crimes or alleged war crimes in the 2014 war between Israel and Hamas in Gaza. So this second round again is brought forth based on the Genocide Convention, and here it's the idea. South Africa's case is based on the idea that there's a danger of genocide or an accusation of genocide against the Palestinian people, of which there are several claims that are made against Israel. So up until now, some of which have to do with initially with killing large, sort of the amount of killing statements, intent to genocide based on statements by members of the Israeli government, and then also the issue of food provisions. And then in addition to that, there has been, so that's really, so there, that's really what's been happening between the state of Palestine and the attempts by the PLO to use the international bodies in order to strengthen their political objective of gaining a state, yeah, and with the maximum leverage in relation to Israel, right? If they get a state unilaterally through international community and international law, then they don't have to negotiate on difficult positions, which they would have with Israel. So that's for the International Court of Justice. Then we have the ICC. So as I said, the ICC is a different body. Israel is not a signatory, but having achieved this kind of semi-state status, Palestine is a signatory to the Rome Statute, and therefore they claim that the ICC does have jurisdiction over crimes that happen in the state of Palestine. And so, but unlike the ICJ, it's not a state that brings a claim to the body. Rather, it's the body itself that prosecutes individuals for war crimes or for other crimes. So as you know, or maybe you've read in the news, then there have been warrants for, on the side of Hamas, Hania, Sinwar, Deif, and Yoav Gallant and Netanyahu, on the side of Israel for various crimes. So this, of course, Israel denies that they have any jurisdiction. And this, of course, is very concerning for Israel. I mean, it should be concerning for the Hamas leadership also, because it means that that these leaders can be arrested. So for the moment, that trial is in process, and we will see the previous one for the International Court of Justice has not required Israel to stop its war against Hamas, but there was a requirement to halt matters with Rafah for a while, but there was a requirement that Israel comply with giving food, etc. There's one more thing that's important in relation to the ICC and Israel, which is that if Israel prosecutes its own, then the ICC cannot prosecute them. So there is an argument that's being made that the IDF's legal counsel should be prosecuting soldiers or individuals for potential war crimes so as to avoid matters going to the ICC. So that gives us a little bit of background now to discuss a little bit the issue that really comes out, the question of bias and the question of the importance of these matters. Because the ICJ doesn't really have any way of enforcing things except through the Security Council, which is in a way is a separate body, and the matter or the issue with international law has a lot more to do with legitimacy and symbolism, etc. You know, what I think in the long term, people are worried about Israel's isolation in the international community, but also people's understanding of Israel and Israel's legitimacy. And I think this is an important point. It needs to be stated, though, I think, you know, most observers who are sympathetic to Israel understand that Israel has, you know, been scrutinized far more than many other states in the international community, and that I think it's very legitimate to talk about a UN bias against Israel. But I think that we can also talk about the fact that treaties, the treaties that created the post-World War I reality are not necessarily just. You know, we have states, we have peoples to this day who don't have national self-determination and who live in other states. The Kurds are an example, the Tamils are another example. So international law until today hasn't really provided national self-determination for all peoples in the world. The treaties that exist that are the foundation for various states are not necessarily just, don't necessarily correspond to the principle of national self-determination. And there are issues in dealing with multinational areas, and there are also kind of issues in dealing with what constitutes a people that deserves national self-determination. So international law not only has some difficulties with sources, even though there are, you know, some sources or some precedents have, or some treaties have greater strength than others, but there are also, in terms of the categories or the concepts, there's some difficulty. That being said, in the 20th century, there are a lot of countries and a lot of people who would like to see international law replace wars as the means of resolving conflicts and disputes because of the devastating impact of wars. And so really the intentions of international law and of these international bodies are good. But for the moment, we can see that there is a significant bias in terms of the focus on Israel in relation to other states, particularly in the UN resolutions, and also in the ICC and in the ICJ, and in sort of NGOs and the international community trying to robustly help the PLO in their objectives of gaining a state outside of a negotiated agreement. So I think that in terms of an introduction to this, I hope that this is clarified for people the source of international law, the different bodies that are right now at work, their jurisdiction, and their ability to enforce. And so I think since this is a hot topic, I'm going to open the floor to questions, and then we can deal with them as best I can.
Thank you so much. And we are turning to questions now. So everyone, just a reminder, you can submit your questions using the Q&A box on your screen. We have a lot of interesting questions, and some of them relate to each other. So I'm going to start with one about the ICJ. Does it have jurisdiction over Israel relating to the occupied territories case? And similarly, why is there a case against Israel at the International Criminal Court, Criminal Justice?
So the case was brought by the state of Palestine, and the idea, this is, I'm sorry, I forgot to mention this part. It's an important aspect of it. So in addition to the question of what the legitimate boundaries are of the state of Israel, right, and whether Israel is an occupying power, right? And I gave this minority opinion that says Israel was never an occupying power. It inherited the entire borders of the mandate. That's one position. But the other position, which views the national rights of the Palestinians as paramount and takes in conjunction with the partition resolution, says that the actions of the Israeli government in the West Bank are actions that constitute annexation, and also that the settlements constitute a crime in relation to the Geneva Conventions of an occupying power it's being illegal for an occupying power to transfer populations to the place that they've occupied. So the claims by the state of Palestine, right, to the ICJ are that Israel is effectively committing crimes, and there are other war crimes that are listed in the occupied territories. So theirs is less about the legitimacy. They don't bother with the point of whether this territory was legitimately Israeli territory. They don't accept that perspective. What they are contesting is the Israeli perspective, or the perspective of some of Western states that support Israel, that Israel acquired those territories defensively and maintains them defensively until there's a negotiated solution with the Palestinians. So that's, but there is jurisdiction in the sense that because Palestine is a member of the United Nations, and Israel is also, then therefore the ICJ can rule on this. But the issue is they can't really enforce it, and for the moment there hasn't been a Security Council motion. What one could imagine is that the Security Council decides, and this is certainly what Palestinian nationalists would like, is that the Security Council would enforce this through sanctions against Israel, economic sanctions or others, and that it wouldn't simply be a motion. It wouldn't be a court decision, or it wouldn't, a sort of UN General Assembly decision, both of which are not enforceable in that way. So that's the direction. And the idea is that from the perspective of the political strategy of the PLO is to incrementally use international law to sort of increasingly isolate Israel and to move public opinion closer to accepting the position that Israel has to, to criminalize Israel, or to be able to finally get to some kind of UN Security Council resolution against Israel. So that, that's one of the ideas. So I think if it gives, so to the answer, that's a long-winded answer for yes, there's jurisdiction. For the moment, no, there's no enforcement. But the objective is to get that there. And the symbolic, we shouldn't underestimate the importance also of, once Palestine is created, even as a, as this kind of this semi-status as a state, or other countries recognize it, that this increasingly kind of makes it real. And the opposite is also true. When a treaty creates a state, right? Like if you think of the Kurdish case, Kurdistan is not real in any kind of legal sense, because the treaties created the current borders of Turkey and Syria and Iraq, which don't include Kurdistan. So there's a way in which the all of this discussion within the international legal community also has its own impact on public discourse.
Okay, we have a few comments here that relate directly to what you were just saying. One person said, I didn't realize there was a state of Palestine. Another person said, there's a Palestinian Authority. Another person said, what are the boundaries of this state of Palestine that you're referring to? And also related, someone asked, how does international law and the Palestinians reconcile multi-generational refugees who live within the boundaries of the Palestinian, I think they left out a word, claim to statehood? So all these things are related. And I think a lot of people are anxious to hear the answer.
Okay, so this is what I'm talking about in terms of the fuzziness of international law. So at present, there are countries that recognize the state of Palestine, right? And it has observer status at the UN, but it doesn't exist. So there's really a range of opinion. There are people who say there is no state of Palestine, right? Because there is no negotiated peaceful solution with Israel, which has led to the major powers to recognize the state of Israel, including state of Palestine, rather, including the United States, but also, so there's one sort of kind of opinion that says there is no state of Palestine, right? And then there's another and there's kind of a kind of gray area in between, and then there's another that says, in fact, functionally there is, because the PLO has functional authority and has governing bodies. And it's recognized by various states, and it has not observer status at the UN, and therefore, so that's what I mean. What the PLO has been, I think, very strategic and clever in advancing this objective of state of Palestine, even if they understand that there are still hurdles, through these international bodies, right? As a kind of alternative means to a negotiated solution with Israel. So the answer is there is and there isn't, right? A state of Palestine. And I mean, I think this is true. The question of the sovereignty of different countries is one of the fuzziest areas of international law. Came up with the case of Kosovo. Can an area just secede from a state that is created, and or it came up with Quebec, secession? Who recognizes it? Does the previous state then have to accept the recognition of other countries in the international community? So these are all gray areas that don't have, unlike some of the treaties. And as I said before, some of the treaties are disputed. So treaties have kind of a stronger standing in international law. But the justness of the treaties are disputed by many people. So international law is kind of gray in this regard.
Okay, so I have a very long and slightly related question. Um, it's always been a complicated history, and you do a very good job of delineating many of the different perspectives. Israel's relationship with the media doesn't help Israel's legal rights, but Israel doesn't help by being lazy about their image of public relations. That's a comment that leads to the question. The American Jewish community is split between those that support Israel's rights regardless of the government's policies and those who do not see their Jewish values reflected in the methods of the government that they've used to accomplish their goals. Do you see a way for Israelis to lead the discussion to help American Jews to see the bigger picture? Or are they also divided by the internal argument that will keep Israel from being effective in promoting their rights to the larger world?
Well, in terms of international law and in terms of the conflict, there are kind of two issues. One of them is that
There's a part two.
okay.
You're answering this in part, but how can American Jews best help Israelis to navigate the media or impact Israel's legitimacy in the eyes of the world? So that should be part of the same answer. Thanks.
Okay, so the question of Israel's legitimacy, um, I think is a broader question, a more important question. I mean, if you look at the partition resolution, 1947, many countries did not accept the partition, and in fact, not a single Muslim country accepted the partition. Only Christian countries did, and a number of Christian countries did not. So there is a broader, I think that we tend to forget, but there is a longer history of difficulty in accepting Jewish sovereignty in the land of Israel that I think hasn't fully been overcome, certainly not in the Muslim world. And in some ways, in some parts of the Christian world, hasn't fully been overcome either. And there are other peoples who similarly have a difficulty in having their sovereignty accepted for various cultural and political reasons. In the case of the Jewish people, it has to do with Islamic attitudes towards Judaism and towards the Jewish people, something that I addressed in my talk on the Abraham Accords. So I think that it's not fully a level playing field. It's not that Jewish national self-determination is fully accepted around the world. And I think that the American Jewish community has to come to terms with this. And it's sort of, though there was a period after the Holocaust where it seemed to be, particularly in the United States, we see now in the campus protests, the Muslim, and I would say not all Muslims, because the Abraham Accords are really showing that there is a different Islamic Muslim perspective, but the Islamist perspective, which didn't accept it, coming more to the fore, and that perspective then uses all kinds of terminology to kind of attack certain aspects of international law. One of them is this idea of national self-determination. The claim that Israel is a settler colonial state and not the national homeland of the Jewish people it's not just symbolic. It also kind of aims to address one of the pillars of Israel's legitimacy in international law as being the expression of Jewish national self-determination. So I think the first thing that the American Jewish community can do is recognize that there is this problem, and that it's not really, whether you like the current Israeli government or not, that this is a separate issue, which is that we have bodies within the Muslim world, Islamists in particular, and we also have groups within the far left and also the far right, which never accepted the legitimacy of the state of Israel, and for various complicated reasons have become more powerful now. And we simply have sort of to understand this, and that I think that there can be unity among all people, whatever the politics of the current government of Israel, on this point that the state of Israel is an expression of the national self-determination of the Jewish people, and if you want to get more technical, that it's legal under international law through the various treaties post World War I, and through its de jure and de facto de jure acceptance by most states in the international community, and its acceptance in the United Nations. So I think I think the American Jewish community can wholeheartedly, along with Israel, just say this attack on legitimacy of the state of Israel must end. from all of these different perspectives, and just kind of focus on that. And then afterwards, there is a discussion, and this is, really, it has kind of two dimensions to it. One of them is the military and security dimension, and the other one is the symbolic dimension. The formula of land for peace was kind of the formula that a certain cross-section of both the international community and the Israeli politicians sort of moved forward with since 1967, but it's not a formula that has currently worked, which is that there have been, multiple attempts at creating a Palestinian state, and some, if you look at post-Oslo, the different accords with both Barak and Olmert, which were not accepted by the Palestinian Authority. So I think the other thing that the American Jewish community can say is, while it is true that there is a cross-section of the Israeli political leadership that would like to have sovereignty, and I mean, I think one should be blunt about this. It's true. There are various parties in the current government which would like to have sovereignty over all of the West Bank, and in some cases even Gaza. At the same time, it is very clear that the Palestinian leadership has had multiple opportunities to create their state, and they have not done that. And also that they have squandered and stolen international money in order to perpetuate. Not only have they failed to accept a negotiated solution under the Oslo Accords, but they've also used all of this money from the international community in order to commit acts of terror. And this is true both for Hamas, but also for the PLO, which continues to give money to people who have committed terror. So I think that those are 2 points where, whether you agree or not with a maximalist view of, whether you are firmly in the camp of land for peace or you are in the camp of Israeli sovereignty over the whole region, I think that those 2 points can be embraced by everyone, because they're empirically true. That Israel is a legitimate state under international law, and any attempts, to go against that are anti-Semitic. And then the second point, which is that there have been multiple opportunities for the Palestinians to create their own state, including in 1947 itself, and subsequently, that they have not taken, and that they have not, and that they continue to commit war crimes by their acts of terror against civilian populations, including most recently October 7th. There's no, I think that the American Jewish community can simply just discuss that. And I think that this is extremely, I would even add that there's a third dimension, that the American Jewish community has to understand that in doing those two things, they are doing a favor to the entire region. There is no reason for regional security and peace, and for the well-being of anybody in the region, to pander to Islamist perspectives, right? Which is what the far left is doing. The state of Iran is not doing anything good in the world, right? They're fossil fuel promoters. It's a state that terrorizes its own citizens, etc. So Islamism is the fascist dimension of Islam, and we have countries, Muslim countries, most of the allies of Israel and Western countries have in fact banned the Muslim Brotherhood as parties, and banned and have poor relations with Iran. So legitimizing this discourse against Israel is legitimizing Islamism, which is the Muslim fascism against those strands within the Muslim world, which are taking a more pluralistic and open perspective, not only to Jews, but to Christians in the region, to other ethnic groups in the region. So nobody is doing, so having a united front for a democratic Middle East means upholding the legality of the state of Israel in international law, and also means reminding the international community of the opportunities that the Palestinians have had, and reminding the international community of the ways in which Islamists are committing war crimes and are really not the future. And then afterwards, it's really an internal Jewish discussion about the future. And there can certainly be a dissension in terms of the question of the holy sites, and in question of whether Israel should a maximalist perspective or not. But quite frankly, and this is one of the tragedies of the current discourse, the Israeli quote unquote far right, because there are people who view Israeli politicians as fascists, and there are people who disagree with that perspective, which also comes back to what we've talked about on their positions of international law, right? Whether the West Bank is occupied or not occupied. But this is, if you look at the grand scheme of things, this is secondary to the types of crimes being committed by Islamists, right, in the region and in the world. And so the American Jewish community, I think, needs its priorities to be straight. I think that we need a kind of popular front, or we need a combined bipartisan understanding that Islamism is the problem, not Islam, that we need to, and that it's destabilizing an entire region, not just Israel, and to focus our efforts on that.
Thank you so much. This was a great perspective and very helpful. Do you have any final comments before we wrap up?
There are no more questions?
We don't have really time. We have to end on time. Although, if you'd like to answer further questions, if you want to give out any contact info, people could.
Yeah, if people would like to ask me any further questions, I mean, I think the objective with this talk is that now that you have a kind of lay of the land, you can go in. I just really recommend reading the different opinions and different perspectives. But I think, I think as someone who, on the one hand, sees the value and the importance of international law, but on the other hand sees, and also international organizations like the UN, but at the same time sees the kind of persistent bias. I think that when we examine this, we need to consider all of this. And I think that particularly with international law, in contrast to national law, there's a lot more room for differences of opinion, and there's a lot more difficulty with the sources and application. I think that anyone, whenever you're reading the news or you're reading the different opinions, to keep that in mind as you go through and you make up your own mind about this conflict and the role of international law within it.
Thank you so much for helping us navigate through a very complicated topic and filling us in on some of the most important things we need to know. Our next Scholars Circle program features Dr. Andrew Pessin, Setting the Record Straight, Part 3, and that will be held on August 14th at 7 p.m. Eastern Time. Thank you, and we hope to see everyone again, and thank you so much, Olga.
You're welcome. My pleasure.